Danish, can you confirm?
Yes, sir. You're audible.
Okay, fine. With this, I'd like to welcome everyone for today's webinar. This is the third webinar that is being organized by Assam Rajiv Gandhi University of Cooperative Management, School of Public Policy and Law. I'm the host for today's webinar, myself, Dr. Dipam Borua. I'm presently the HOD, the Department of Law at the University, Rajiv Gandhi University. So some of you, I think, are already known to us, though many of you have already attended the last two webinars. And some, I can see that they are, for the first time, are here. I'll give just a little brief introduction about the university and about today's speaker. Then we shall continue with today's webinar. And now to start with, as I've already told you myself, I'm Dr. Dipam Borua. The university that I'm working right now is the Assam Rajiv Gandhi University of Cooperative Management. It's a state university enacted under the Assam Rajiv Gandhi University Cooperative Management Act by the Assam legislature. It is situated in the Sivasagar area of Sivasagar. Presently, we have law, management, commerce, IT, those subjects, departments. And presently, we are running in law school, we are running the LLM one-year course, apart from the PhD courses. So that's a little bit about my university. The speaker for today's program, today's webinar, is an advocate. His name is Advocate Abir Phukan, who has been practicing in the Delhi High Court and Supreme Court of India for more than now 15-16 years. He has passed out from the prestigious Indian Law School, that is ILS Law College. It's one of the, I think, the most oldest law school in India. So from there, he went on to Delhi for his practice. He started his practice. He was a junior of Mr. K. Venugopal, senior advocate, a very renowned advocate actually of Supreme Court of India. And of late, a few years back, he has established a law firm along with three of his friends. It's called the KMNP Law Firm. It has its offices in Delhi, two offices in Delhi, one in Kochi, I guess. So they have recently opened an office in Guwahati as well, and then Bangalore. And they have not only clients from India, but they have deal with the international clients as well. So he has very vast experience in the field of, as far as comes to the practicing law, as a very seasoned lawyer. So with this, I think I will request the speaker for today's session. Abir Phukan is already here. So I would request him to kindly unmute his mic and proceed with today's webinar. Welcome you, sir.
Thank you very much, Dr. Dipam Borua. I hope I'm audible to all.
Yeah, you're fine, sir. Thank you. You can continue. One more thing, just before you start,
topic.
Just a minute.
I'm going to speak on. Yes.
Yeah, I think a few participants I'm going to unmute all of you right now. So some of you have already, their mics are, I think, okay, I'm unmuting all of you. So I request everybody not to use their mic during the presentation is made by the speaker. And after the session is over, you can do two things. Better will be, there is a chat option available in the screen. So you can type your questions in the chat box. So that way it will be visible to me as well as to the speaker. So the speaker can choose the questions accordingly, because we have a limitation of time as well. So as many as questions he selects, he may answer those questions. So I request the participants to kindly, type the questions that they may have in the chat box only. So there will be no disturbance during the presentation. So over to you, sir. I think your mic is not or you have to unmute yourself. Mr. Phukan, you will have yeah. Now you can continue.
So, as the topic for today suggests, I'm going to speak on key concepts of legal drafting. Now, drafting has always been a very, very important part of any legal proceeding in any court or tribunal. Now, the times that we are going through, the pandemic, on account of COVID-19, which has affected each and everyone in the country, in the world. So lawyers also have not been spared. So it's been a tough time actually grappling with the pandemic and coming to terms and carrying on with our normal lives and with normal hearings in courts. Courts have not shut down till now, and hearings are going on through video conferencing. And we are still evolving a process and streamlining the available resources to come up with the best possible way forward for all lawyers across the country. And Supreme Court has been very upfront in this whole process, and Supreme Court has also been experimenting with a lot of video apps, and also has been trying to make it as easy as possible for the lawyers to conduct these hearings. So in these times, when it's so difficult for you to be appearing before a judge in a particular court and making arguments, making submissions on behalf of your client, the role of drafting assumes a lot of significance, a lot of importance. It has always been a very important part of a lawyer's life, but I would say now, because of the constraints which we are facing and which we will be facing for a while on account of the pandemic, the importance that you give to drafting as students, that all of us give to drafting, should increase. In fact, that should be the focus from the very beginning of a lawyer's career. You see, the minimal now is almost nil. So a good draft of a petition or of a reply can really do wonders to your client's case. So keeping these things in mind, I would like to start by pointing out certain tips.
His mic and proceed with today's webinar. Welcome you, sir.
Thank you very much, Dr. Nipamura. I hope I'm audible to all.
Yeah, you're fine, sir. Thank you. You can continue. One more thing, just before you start,
topic,
just a minute.
I'm going to speak on. Yes.
Yeah, I think a few participants I'm going to unmute all of you right now. So like some of you have already, their mics are, I think, okay, I'm unmuting all of you. So I request everybody not to use their mic during the presentation is made by the speaker. And after the session is over, you can do two things. Better will be, there is a chat option available in the screen. So you can type your questions in the chat box. So that way it will be visible to me as well as to the speaker. So the speaker can choose the questions accordingly, because we have a limitation of time as well. So as many as question he selects, he may answer those questions. So I request the participants to kindly type the questions that they may have in the chat box only. So there will be no disturbance during the presentation. So over to you, sir. I think your mic is not or you have to unmute yourself. Mr. Fukan, you will have yeah. Now you can continue.
So, as the topic for today suggests, I'm going to speak on key concepts of legal drafting. Now, drafting has always been a very, very important part of any legal proceeding in any court or tribunal. Now, the times that we are going through, the pandemic, on account of COVID-19, which has affected each and everyone in the country, in the world. So lawyers also have not been spared. So it's been a tough time actually grappling with the pandemic and coming to terms and carrying on with our normal lives and with normal hearings in courts. Courts have not shut down till now, and hearings are going on through video conferencing. And we are still evolving a process and streamlining the available resources to come up with the best possible way forward for all lawyers across the country. And Supreme Court has been very upfront in this whole process, and Supreme Court has also been experimenting with a lot of video apps, and also has been trying to make it as easy as possible for the lawyers to conduct these hearings. So in these times, when it's so difficult for you to be appearing before a judge in a particular court and making arguments, making submissions on behalf of your client, the role of drafting assumes a lot of significance, a lot of importance. It has always been a very important part of a lawyer's life, but I would say now, because of the constraints which we are facing and which we will be facing for a while on account of the pandemic, the importance that you give to drafting as students, that all of us give to drafting, should increase. In fact, that should be the focus from the very beginning of a lawyer's career. You see, the minimal now is almost nil. So a good draft of a petition or of a reply can really do wonders to your client's case. So keeping these things in mind, I would like to start by pointing out certain tips which I feel are very, very important and which are based on the experience that I have garnered by being associated with a very renowned, reputed, and a senior counsel in the Supreme Court, who was also a very tough taskmaster and who would go out of the way to teach all of his juniors very basic things, basic concepts. So, initially when I joined him, before actually joining him, I spent a few years in the trial court and in the High Court of Delhi, learning the basic trial work and appearances in courts for miscellaneous hearings and all that. But when I became associated with this senior advocate, Mr. Venugopal, to read a matter which is coming up in the Supreme Court and to brief him So, I mean, when I briefed him, I told him the facts and what the case is about and what the case of the opposite side is about. Completely different way. You have to think through. Rung a bell in my mind that you as a lawyer should always think through. You need to cultivate that habit of analyzing facts, analyzing the law, even analyzing the law that goes against you. You need to understand each and every word that occurs in the applicable laws, understand its meaning, understand the different ways in which the words can be interpreted. So don't think that, when a client comes to you, you read the law, you think it's in your favor, and you have an open and shut case for the client. It's never that simple. You have to play the devil's advocate all the time, and you have to see how your opponent is going to put up his defense also. So keeping all these things in mind, I'll just broadly, highlight a few points which I feel is important when you start your career. I'm sure there may be some advocates also in the audience, but I would just like to highlight these points. First, as I said, is on thinking through, where you analyze the facts, you analyze the law, and even the judgments that go against you, understand the meaning and interpretation of each and every word in the applicable laws. Then, whatever doubts you have, you should discuss those doubts threadbare with your clients and try to overcome the weaknesses in your case. You have to identify weaknesses. It can't be that, there's no weakness in your case. You identify the weaknesses, you discuss it with your client, and then you decide, your strategy, where to go, which court to go, what jurisdiction to invoke, and what relief to seek from the court. So unless you're clear about these basic things, which court to go, which jurisdiction to invoke, what relief to seek from the court, you should not start drafting even a sentence. Then, once you're clear about the strategy, you start drafting. And my experience is that you should never be happy, never be contented with the first draft that you produce. Only then you can improvise. Once you're satisfied with the revised draft, right, you work on it again and again, you rework. See, these are things which will come to you automatically, naturally later on. But in the initial years, it's very important that you give an extra bit of importance to these methods. So after reworking on it, you finally finalize the draft. And while drafting it, few things which you need to keep in mind are, first is clarity. Use plain and simple language. Don't think that by using complex words, by trying to have a very sophisticated vocabulary in your draft, you will impress the judge. In fact, you may confuse the judge. So you should always bear in mind that the judge will be going through multiple cases. He will be reading multiple petitions, multiple replies, written statements, and other forms of pleadings. I'll come to pleadings in a while, what exactly forms pleadings and what are the important areas in pleadings. But so you have to bear that in mind, that the judge will be looking at multiple cases, will be reading several petitions, replies, etc. So the time that you will be getting from the judge to go through your petition may be very, very limited. So therefore, the clarity cannot be compromised. You need to have simple, plain language in the draft. And you should ensure that by reading the petition just once, the judge understands what you are trying to achieve for your client. I will recall an incident that happened when physical courts were still functioning in the Supreme Court. In the Supreme Court, we usually file special leave petitions against judgments of the High Court, which is a discretionary jurisdiction. And the structure of the special leave petition actually begins with a synopsis. Then it has questions of law, then it has grounds. And there's a standard prayer which is applicable in all special leave petitions. So the judge said that I read your petition, I read the synopsis, I read the judgment of the High Court at least more than 2 times, but I'm still confused. So the judge said, you withdraw this petition, you draft it again and you file it, because we cannot go ahead in this manner. So you should be respectful towards the judiciary's time. You should be respectful to the efforts put in by the judge to understand your client's case, and try to have a simple draft which conveys exactly what you want. What are the facts which give rise to a cause of action which entitles your client to the relief? While doing so, you should avoid unnecessary sentences or explanations. If you have too many unnecessary sentences and explanations, which you think will, give a different impression, which will add to the sophistication of the draft, you should remember whether these sentences actually does that or it only adds to the confusion. The object should be that you should never ever lose focus on the central issue in the draft, in the petition. You have to remember that when you're practicing in the trial court, in the civil court, because we usually call it the trial court here, a lot of lawyers call it even the civil court. So when you're practicing the civil court, where actually the case, a civil case actually begins. Of course, we have some high courts in the country where original jurisdiction is vested with the high court also. So there are many suits of above a particular pecuniary jurisdiction, which commences in the High Court. Like in Delhi High Court, suits above 2 crores can be filed straight away in the Delhi High Court. But below that, you have to go to the district court. And the concerned judge, whether it's the additional district sessions judge or the lower judiciary, will have jurisdiction, and he will decide it, and it will go up all the way in appeal if either party is not satisfied with the outcome, the judgment. So what I want to emphasize here is that drafting a plaint or a written statement or a replication, which constitutes the pleadings in a suit, is extremely important, because ultimately, if the case goes all the way up to the Supreme Court, the draft will be tested, will be scrutinized, threadbare. So when you draft a petition for a client in the trial court, you should just keep that in mind, that someday, maybe 15 years, 20 years, because the judiciary works really slow in the country, and it takes time before justice is eventually delivered. So keeping that in mind, you should always emphasize that your draft might someday be tested and scrutinized by the Supreme Court. So therefore, that extra bit of importance is always necessary. Now, when you go to the civil court, you have to always focus on something called the cause of action, which those of you who have studied the Code of Civil Procedure will be familiar with. Cause of action is nothing but the bundle of facts which will entitle you to a relief before the court. So keeping that in mind, you have to have focus on the cause of action. And why it is so important is that if a bare reading of the plaint does not disclose a cause of action, the court has the power under Order 7, Rule 11 of the Code of Civil Procedure to even reject the plaint at the very threshold. It need not go into trial, it need not go into elaborate hearings, nothing. It will just look at the plaint, and if it is of the opinion that cause of action is not made out, then it will, I'll just come and deal a little more in detail with the structure of a suit, pleadings generally as envisaged in the CPC, the Code of Civil Procedure. I would just like to, touch upon a criminal complaint also. When you draft a criminal complaint, what do you keep in mind? You need to keep in mind the ingredients of the offense that you're trying to make out. Ultimately, the criminal court will examine the offense are made out or not. So everything that you in the complaint should, if the accused in the case goes to court and challenges it and says that no offense is made out, the court does not throw out offense are made out on the basis of suit. Just like you have to make out a cause of action, right? Why you have come to the court and why you are entitled to these reliefs from the court. In a criminal complaint also, you have to make that effort to make out an offense. So it's somewhat the yardstick for both proceedings are somewhat similar. So now I'll come to pleadings. So what do you understand by pleadings generally? So I'll deal with that first. See, before coming to pleadings, actually, I would say that, when you start your career in law, there are usually clients coming with a legal notice. Someone wants to send out a legal notice to somebody against whom your client may be aggrieved, or he may come to you to file a reply to a legal notice. So these are also very important things, these are where your drafting skills are tested. So you need to focus and understand and sit with the client and make out a case, even in the legal notice or in the reply to the legal notice, which will ultimately stand the test of scrutiny in court, if at all the case goes to court. Foundation should be solid, should be unshakable, so that no matter what defense the other side comes up with, you will succeed. So now I come to the pleadings part. So in a civil suit, it's the plaint, the written statement, and the replication. Replication is not actually envisaged in the CPC, but nevertheless, courts have recognized it as a part of a pleading, and you can take leave of the court and file a replication to rebut the case of the defendant in the written statement. So now, as I said, when you file the suit, keep in mind the structure of the plaint. You need to make out a cause of action, and you need to also adhere to the principles of pleadings. Now you need to, if you're going to court, then you have to affix the jurisdiction of the court which you're trying to approach. So in CPC, Order 6 deals with pleadings in general. So as I said, it deals with the plaint or the written statement, and the CPC is also very clear that the pleadings should deal with facts to adduce evidence at a later stage of the suit, at the trial stage. But at the stage of pleadings, you need to make out your case in facts. You need to ever allege each and every fact which, according to you, constitutes the cause of action. You have to bear in mind that any relevant fact, any material fact cannot be left out of the plaint. If ever it happens that you have missed out on some relevant facts in the plaint, then you have the option of even amending the plaint. The same applies to the written statement also. You can make amendments under Order 6, Rule 17 of the CPC. Of course, subject to the law which has been laid down by the Supreme Court. And you have to make out a case that it is absolutely necessary to amend the plaint. So, insofar as plaint is concerned, you have to give the facts, as I said, and avoid the evidence. Evidence will be, you'll get the opportunity to lead evidence at a later stage. And you have to give all essential particulars, right? You don't have to expressly plead the law, because you have to assume that the court is aware of the law. But you have to make out the basis, at least, under which what provisions you're seeking the relief. That needs to be made out. Now the object of pleadings is to help the court determine the issues which require to be adjudicated in the court. So based on the pleadings, that is the plaint, what is alleged in the plaint, what is alleged in written statement and the replication, the court, that is the judge, will frame issues. They can even ask the parties to submit draft issues, but ultimately they will frame the issues, and the object of pleadings is to help the court frame issues so that ultimately you narrow down the dispute into certain questions. The purpose of framing issues is to enable the parties to be aware as to what are the areas, what are the aspects, factual aspects on which he needs to lead evidence. And it's also, if you really look at it, then object of pleading is also to avoid unnecessary expense and trouble, save public time, eradicate irrelevancy, and assist the court. Now, as I was mentioning earlier, regarding amendments, Order 6, Rule 17 deals with it. So the principles which have been laid down by the courts are that you can amend the plaint provided the amendment is necessary for determination of the real question in controversy. So you cannot seek the leave of the court to amend the pleading just to add something which might be completely irrelevant. You have to show the court that this is relevant to determine the real issues which have arisen. And it's always advisable that you should move amendment of your pleadings at a stage prior to the stage of that will also be very skeptical as to whether to allow the amendment or not, because that alters the very nature of the suit. That could alter the very nature of the suit. So it's always advisable that you move the amendment quickly as soon as you feel that it is relevant to amend the pleading to bring up certain aspect which you may have lost sight of when you file the case. So, but ultimately what the courts keep in mind is that the object should be to advance the cause of justice. Even while considering applications for amending pleadings at a later stage, the court has to be sympathetic, and the court should keep in mind the object, which is to advance the cause of justice. Then I would like to briefly deal with the written statement. One fundamental thing which lawyers need to keep in mind is that in a civil suit, it is extremely important to the written statement has to be filed within the time stipulated in the CPC, which is 30 days from the date of summons. Now that time can be extended also for a further period of 90 days, but even that cannot be taken for granted, and you have to satisfy the court that there was sufficient cause because of which you could not file the written statement within the 30 days, and you seek extra time for that. And beyond 90 days, it is very difficult, and unless you have genuine strong reasons, it may be difficult to convince the court to extend the time. And if you fail to file the written statement and get it on record before the court, it becomes very difficult to have a defense. So virtually you will be knocked out of the proceedings. So it's very, very important for a lawyer to keep in mind the time within which the written statement is filed, which starts running from the date when the summons are received from the court. And one more thing you need to keep in mind insofar as a written statement is concerned is that because if you're drafting a written statement, you need to counter each and every allegation made in the plaint. And that you can do by denying a lot of things which are being said in the plaint, but such denials need to be specific. It can't be evasive denials. That's what the CPC also says. It uses the words that denials should be specific and it can't be evasive. So you have to deal with the issue. You cannot skirt around the issue and beat about the bush and say that I'm just denying it. If something serious allegation is made against you and you just you try to avoid the issue by saying that I deny it, but without giving an explanation, then there might be problems for you later at the stage of the trial, and the court might in fact take an adverse inference against you. Another important principle that one needs to keep in mind is that facts which are admitted in the written statement. I talked about denial first, and now I'm talking about admission. Maybe I should have spoken about admission first. See, if a fact which is alleged in the plaint is admitted in the defense in the written statement, that means that it's an admitted fact for which you do not have to use evidence, you do not have to prove. So that is another principle that you should keep in mind. In fact, if the case of the plaintiff in the suit is admitted, then there is even a provision where you can ask for a judgment on admission. I believe the provision is Order 6, Rule 12, where basically you can, based on the admissions made by the defendant in his case, you can actually straight away ask for a judgment to be pronounced by the court, a decree to be awarded by the court, instead of going for a full-fledged trial or of leading evidence and all that. Now, I mentioned about replication rejoinder also, though they are not contemplated as a pleading, but it's become a practice now, and courts usually permit parties to file replication to rebut the submissions which are made in the written statement. Now, I spoke about Order 7, Rule 11 also, which by which the court can reject a plaint. So as I said, one of the grounds on which a plaint can be rejected is where no cause of action is made out. So this is something which a lawyer representing a plaintiff as well as a lawyer representing a defendant needs to keep in mind. Because if you fail to make out a cause of action, it gives a excellent weapon to the opposite side to get the suit thrown out, to get the suit rejected, the plaint rejected. It could also be rejected on other grounds, like if it is in violation of some statute. But cause of action is fundamental, but because that is something that you, while drafting it, should never lose focus. That ultimately, the cause of action should plaint is read by the judge. So these are some of the basic essential things which I thought would always be very important when you draft a suit, a plaint, or a written statement. Even while drafting writ petitions or filing or drafting special writ petitions in Supreme Court, these are some of the key concepts which, if you are able to grasp at an early age in your career, this will help you immensely as you go along. So therefore, having the fundamentals sound, the foundation being strong and unshakable is very, very necessary. So, as I said, it's a discretionary jurisdiction under Article 136, and even the writ jurisdiction is a discretionary jurisdiction. So, it's unlike original jurisdiction, that in a civil suit, if you have made out a cause of action, if you have made out that you are entitled to the relief, the courts are bound to interfere. Writ jurisdiction and special leave, Article 136 jurisdiction of the Supreme Court, and the writ jurisdiction under Article 32 and 226 of the Constitution, these are discretionary jurisdiction where a lot of factors come into play, right? Equity is at play, but the role of the lawyer who drafts the petition is perhaps as important or perhaps more important than that in a suit. But if you are familiar and sound with the concepts when you practice in the trial court, in the civil court, that offers immense help when you practice in the High Court in writ jurisdiction, or you practice in the Supreme Court in the discretionary jurisdiction like under Article 136. In a normal day, the judge usually refers to what I said in the beginning, that the SLP starts with a synopsis. So usually there are about 30 fresh cases listed before one bench. I mean, if you the pandemic and the virtual court, in normal circumstances, there are 14 benches. So you will, before each bench, there are about 25 to 30 fresh cases listed. And the files usually reach the judge's residence, about a week or maybe even a day before the case is listed. So they don't get much time, and they are also occupied with hearings throughout the week in because fresh matters are listed on something that the Supreme Court calls miscellaneous days, and non-miscellaneous days are regular hearing days. So on miscellaneous days, roughly the judges get very little time to study and be ready with all facts and issues in a petition. So it's very important that the petition you draft, the synopsis itself is very crisp, very clear, and very simple to understand, so that you lay down the issues which have been adjudicated incorrectly by the lower courts, because you are up against judgments of the lower court, which is the High Court. And usually the High Court, because before coming to the Supreme Court, usually 2 rounds of proceedings are already over. Your client will have to go through proceedings before the district court or before some other authority or whatever. Then they come to the High Court, and then they come to the Supreme Court. There may be more rounds of litigation also. I mean, I'm saying at least there should be 2 rounds of litigation. So in these circumstances, you have to make out very clearly where the courts below have gone wrong. And you have to do it in a very delicate manner, in a very humble manner, because you can't attack the judges. You have to keep that in mind. So you have, in a very humble and in a very delicate manner, you have to crystallize the issues. And Supreme Court, as Article 136 also reveals, that they interfere only when there is a substantial question of law involved. So what is the substantial question of law? That is something that you have to first grapple with. That what is the law which has been violated? Because you cannot ask the Supreme Court to re-agitate all factual issues. Supreme Court is, because you, in a normal civil proceedings, you have the suit, you have the first appeal, you have the second appeal. Second appeal also goes into questions of law. But Supreme Court as a standard doesn't go re-appreciate the evidence. There are cases where the evidence has been so wrongly appreciated by the lower court that the judgment of the lower court suffers from what we call in legal parlance perversity. So if perversity is made out, then there are occasions when we may be able to convince the Supreme Court to re-examine the issue. But as a standard, you have to make out some question of law, substantial question of law, which on the face of it will reveal that the courts below have ignored the law, or they have interpreted the law in a manner which is not acceptable, which is in violation of the judgments and the law laid down by the Supreme Court in past precedents. Or there are cases where we even come up where we are challenging a High Court's decision. High Court has taken a particular view, say X. Now, there are cases where other High Courts in the country, say Guwahati High Court has taken a view X, but say Bombay High Court has taken a view Y. So then we also raise this ground before the Supreme Court that, look, the law within the country needs to be settled, because one High Court has taken one view, another High Court has taken another view. So it is extremely important that the law is settled, so that in the future there is consistency. We can also advise the client exactly which way the law stands. I think that's about it. I think I've summed up whatever I wanted to say. Dipam?
So you're done with your presentation?
Yes, I think so.
Yeah, okay, fine. Then would you like to, do you have anything to show? I guess you mentioned about something. You go with.
There's this thing which, yeah, I'll just share that also. This basically summarizes what I discussed. I think you need to enable me to share.
Yeah, just a minute. Yes, it's done.
Yeah, so I'll just start with.
Yeah, just go to that slide share mode.
Yes.
Yeah, that will be easier for others to see it.
Let me try. As I said, I'm very unfamiliar with technology, but I'll try my best. So I hope I am able to share the key points to remember.
It's, I think we all can see, but you can, if you can just enlarge the screen, you can, do that with the slide share button is there. Yeah, just, that one. I think if you can click on that, yeah.
Yeah, has it come
Yeah,
now?
now it's clearly visible.
Okay, so these are the things which I initially mentioned regarding thinking through. To consider the facts about something in a thorough way. These are some dictionary meanings which I have pulled out to understand what thinking through means. To consider the facts about something in a thorough way, to carefully consider the possible results of doing some things. I have thinking through me, you'll have to basically, you can subdivide it into these aspects. You analyze the facts, the law, and even the judgments that go against you while you try to build up the case, and understand the meaning and interpretation of every word of the applicable laws. So this is very important because you don't leave anything to chance, basically. Then you discuss your doubts with the client and ways to get over the weaknesses of your case. Then you be clear where to go, which court, what jurisdiction, and what relief to seek from the court. Then I said that you have to, you should never be happy with your first draft, and you should improvise on it and revise it, and even ask your colleague to give inputs so that you come out with a good solid draft. Then comes clarity. You should use plain and simple language, and remember that the judge is not aware of your facts, so you should have it simple, short, and lucid reading, so that the judge is not bored, because he reads multiple cases and and he has to listen to the lawyers also ad nauseum endlessly for hours throughout the day. So you should do your best to keep it interesting so that the judge is not bored when reading your draft. It's like storytelling, basically. You weave a story from the facts which are being provided by your client. So ultimately what should come out is not just readable, it should be interesting. Then you should avoid unnecessary sentences or explanations and never lose focus on the issue. Then you have to remember that if the case goes all the way up to Supreme Court, then your pleadings will be tested and will be subjected to intense scrutiny. In a civil suit, your plaintiff must make out the cause of action, which entitles you to a relief. In a reply written statement, you have to make out a defense. On the basis of these pleadings, court frames issues based on which parties lead evidence to establish their respective cases. Similarly, if you're drafting a criminal complaint, you have You have to state the facts in a manner that brings out the ingredients of the offense that you allege. Then specific pleadings. What constitutes pleadings? You have to specific documents filed by parties in a lawsuit, stating position of parties, considered as the backbone of a suit. Formal statement requesting a court to grant a relief or pass a verdict in the dispute. This is what pleadings generally mean. Case of a party must be set out in the pleadings, and pleadings also include allegations and counter allegations made by one party and denied by the other. A finding of relief which cannot be sustained or granted, which goes beyond the pleading and is not supported by the evidence. Then pleadings, I'm touching Order 6 here, which I mentioned deals with the plaint. It deals with pleadings generally. Order 7 deals with plaint. Order 8 deals with written statement. So definition of pleading is provided under Rule 1. It shall mean the plaint or the written statement. Rule 2, fundamental principles of pleading. Pleading must contain facts and not evidence. It must be paragraphed, dates, sums, numbers and figures, as well as words. Then Rule 3 to 13, essential particulars to be followed. Example, forms of pleading, condition precedent, departure, presumption of law. Rule 14 and 15, signing and verification of pleading. This is also very important, that you need to get the plaint as well as the written statement signed properly. It needs to be verified properly. The pleadings need to be verified. Otherwise, there is a deficiency in the pleading. So that might also create problems for you later on. Rule 16 empowers the court to strike out or amend any unnecessary matter in pleading. Rule 17 and 18, provisions relating to amendments of pleading. Then objects of pleading. This, as I said, it helps the court to frame the issues. I've also given some citations in case anyone wants to go through them. These are well-settled laws, so you become familiar with all these practices if you spend a little time in the civil court. But it's helpful if you're aware and familiar with these concepts, even when you're a student. I mean, we are of course all students, even when we are practicing law. Then you need to ensure that each side is fully alive to the questions that are likely to be raised. So what I'm trying to highlight here is that when the case is finally argued in court, which is after the stage of evidence, there should not be any element of surprise in what you argue. The other side deserves that courtesy that you address arguments which are founded, which are based on your pleadings. Then comes preventing surprise and miscarriage of justice, avoiding unnecessary expense, saving public time, eradicate irrelevancy, assisting the court. Then these basic rules of pleading, these are by and large pertaining to what you should state. You should state facts and not the law. And the facts stated in the pleadings should be material facts. Material fact as defined by the Supreme Court in some of the judgments. I have given citations in Union of India versus Sitaram and Udhar Singh versus Madhav Rao Sindhya. Then, as I said, you don't have to mention the evidence. You have to file the documents with the plaint, but the affidavit which you file, which forms the evidence, that stage, as I said, comes later after the framing of the issues. And if you come to the last point here, that as a rule, relief not founded in pleadings should not be granted. So this basically sums up the importance of pleadings. That if ultimately a court gives you a relief which you have not specifically pleaded, then that judgment can be assailed in the superior courts. Then there are also judgments which says that certain pleas can be considered, can be construed by implication, even if it is not expressly pleaded. So this varies from facts, you know, and if I have, say, pleaded something which includes within its ambit, you know, impliedly something else, then the court can consider that it is impliedly pleaded in the petition. Pleadings are not statute. Amendment of pleadings in failure. So this is on Order 6 Rule 17 and 18, which I said on amendments when courts grant permission. Advancing the cause of justice is something that the courts keep in mind, and you have to ultimately, the courts normally allow amendments if it is made or sought with the object of determining the real questions in controversy. These are principles when amendment is refused, when the proposed amendment is unnecessary, when the proposed amendment causes an injury to the opposite side and cannot be compensated by cost, when the proposed amendment changes the nature of the cause. So if you've asked for a particular relief, if you say you've asked for a setting aside of a particular sale deed in your suit, now if you've asked for that relief, then later on if you want to amend the pleadings to somehow bring in some other aspect which you have not pleaded earlier and which alters the nature of the suit, then that may not be permissible. When the application for amendment is not made in good faith, and when there has been an excessive delay in filing the amendment, which I mentioned, that it is preferable that you should file it at an early stage. The more the delay, the lesser the chance of the amendment being allowed. Then Rule 18 of Order 6, this also lays down the time limit within which you have to carry out the amendment. The application for amendment, you will be asking for permission from the court or leave of the court to make some amendments in your plaint or defense or in your written statement. So once that is allowed, you have to carry out that amendment in the plaint, whether by filing a fresh listing or by carrying out those corrections in the earlier plaint. So that amendment needs to be carried out within 14 days from the date of the order by which you are permitted. This again sums up the structure of a suit. And Order 7 Rule 11, when the plaint can be rejected. So the law is very clear that you have to just look in the plaint. You cannot look into the evidence or the defense. If the court decides to reject a plaint because of grounds being made out under Order 7 Rule 11, then it must do so based on the pleadings in the plaint. It cannot refer to the written statement. So therefore I said that ultimately the bare reading of the plaint should reveal that a cause of action is made out. Then comes the written statement. Then facts admitted did not be proved. Then there's replication also. Replication has been mentioned by judgments, though I said that it's not part of the CPC, but it has been taken note of, and it's, as I said, it's also become a practice to allow courts to file it. And just one more thing I would like to add here. There is an obligation on the lawyer to not conceal anything from the court. So all material facts, as I said, should be pleaded. So concealing something very material can also go against your client. If you conceal something very material and the other side comes up in his defense that you have concealed this from the court, you have misled the court, then that can also be very problematic for your client. And I mean, it's misleading, and suppression of facts are considered to be almost a crime in legal practice. So as a lawyer, you should always avoid misleading or concealing facts from the court. So because if you develop a reputation towards that, later on it becomes very difficult to get over it. Yeah, I think I have summed up.
Okay, yeah. So there are, I think, a few questions in the chat box already. If you can just click on the chat box, I think you'll
Yes.
see one or two questions over there. So if you'd like to respond to those questions, you can. If you just scroll through the message section, chat section.
Yes. I'm just yeah. How affidavit is related to drafting by Bonismita Kolita. So I'll just take this question. See, affidavit is not really considered part of a pleading, but it is, yes, definitely drafting skills are involved here also. You draft an affidavit by way of evidence. You need evidence nowadays after the amendments were carried out in the CPC in 1999. You have to bear in mind the importance of drafting a proper affidavit also. So as I said, you lead evidence by way of an affidavit. So it has to largely adhere to the structure of an affidavit, but you need to supplement, you need to substantiate all that you have pleaded, you have alleged in the plaint or in the written statement in this affidavit by referring to the necessary evidence to support the facts which you have already alleged. And plaintiff and defendant, yes, both are, drafting is important for all parties, for plaintiffs, for defendants, everyone. So you cannot, rest on the premise that you are representing the defendant, so drafting is not important for me. That's never the case. I mean, drafting is essential no matter who you represent in the legal proceedings. See, there's something on drafting samples provided in the internet.
Yeah.
I really don't know. I don't know much about these samples, but I must say that, you should be very, very familiar with the CPC. CPC is the Bible. It's the key. You need to understand the particular orders dealing with pleadings, order 6, order 7, order 8, thoroughly. If you understand that thoroughly, then you don't really need to, according to me, refer to these drafting samples from the internet. What you can do is you refer to that, and you should borrow, from your colleagues or from your seniors at the bar. You should borrow drafts and look at them and refer to them before you start drafting. So it's not very necessary that you should refer to them. And frankly, I don't have much idea how these drafting samples are. I'm sure there'll be good ones and there'll be bad ones also. So you have to identify the good ones.
There's one more question.
I can't come down further. I think is there any difference between code pleading and notice pleading? I assume you're referring to legal notices and pleadings under the CPC. So if that be so, then my point is that, you see, legal notice, as I said, is like you are sowing the seeds. It has not come to court yet. there are chances that the matter might go to court. So you need to prepare yourself as a lawyer. You need to prepare your client also to face the task when it comes to court, where it gets all the more difficult, right? So keeping that in mind, you have to build your case from the very nascent stage, that is the stage of the drafting of the legal notice. But there is no format as such. As I said, you have to, if you're representing a person who's aggrieved, right, and wants to send a legal notice, then you have to see what are the facts of his case. You should cross-examine him and get all the facts out, and then you should start drafting and see. Before that, you have to, as I said, the key points you have to remember. You should also figure out what are the applicable laws involved. What are the laws that are violated, which stand the chance of being violated, and what are the consequences of the violation of such laws. So once you figure out all that, then you should start drafting the legal notice. Now for the CPC also, it's by and large the same principle that you have to adhere to, but you have to do it in a manner which is prescribed by the Code of Civil Procedure. So the procedure, insofar as the procedure before court is concerned, it is the gospel, it is the Bible. So therefore you have to follow it. There's one question on caveat. Yeah, so see, caveat is basically something that you file in the court to make sure that an ex parte injunction is not granted against you without hearing you. Now, let me give you an example. If, say, you are a municipal authority, you are trying to demolish a particular property which you feel has been encroached upon in public land. So, a party can go to the civil court or even to the writ court, invoke the writ jurisdiction or the original jurisdiction of the civil court, and try and obtain a stay order and injunction against the municipal authority from demolishing the property. So, in a civil court, since we are talking about CPC, the municipal authority may not have any right as such to be heard before an ex parte injunction is granted. So if the municipal authority proposes to demolish the property, say tomorrow, and the client has, the party has approached the court today, so there is no time to hear the municipal authority. The municipal authority has said in the notice that he will demolish the property on Monday, and the client had to move on, say, on Friday or Saturday, and then had to get an injunction. So if the municipal authority in such cases files a caveat, then it ensures that that municipal authority has the right to be heard. Without hearing that, the court cannot pass any ex parte interim order. In the absence of the municipal authority, it cannot pass. It has to hear the municipal authority. What are the tips for drafting a successful grant application for a lawyer? For a grant application, I am not very sure, but well, you have to make out your case, why you need the grant and what is the relevance of your of the topic of your research in today's times, and why some help, by way of grant is would justify work on such a research topic. See, how can we write the fact in concise form? As I said, the judges read multiple petitions, multiple replies, and they hear arguments in so many cases. So you have to have mercy on the judge also, and you need to have something in concise. Concise means you need to not elaborate unnecessarily. You need to have something which is crisp, which is clear, and which does not give unnecessary details, which is completely irrelevant. That's it, I think.
Yes, I guess there is no more questions. If anybody would like to ask questions, then in that case they can raise their hands. Otherwise, we'll call it off for today, the question answer session. Okay. So I think we are done here. So thank you very much, Mr. Phukan, for deliberating on such an complicated issue, I would say, because drafting is the key to success in if you are in the legal profession, especially as an advocate. So and within an hour or two, I know collecting everything and speaking on each and every issue relating to drafting is not possible. But I think within this fixed time limit, whatever you have said, I think that will be of great help to the students, because basically all the participants, they are now college students. There are hardly any passed out advocates over here. So basically, in that sense, because I can already see one student. She has made a comment in the chat section that she is an 8th semester student, and because of the lockdown situation, her classes are not going on at the college and the university. So at the 8th semester, she has drafting classes, drafting course. So I think that way it has been very beneficial to most of the students, and I think they will grasp whatever you have said and apply it when they in future they go into the legal profession as a lawyer. So once again, I would like to thank you very much, and I'll thank all the participants for patiently listening to the speaker and adhering to the rules. So I thank all of you also. So with this, I think we'll come down to the end of this today's webinar. It has been a wonderful webinar, and actually this lockdown in a way has been a blessing for all of us, because every now and then you don't get an opportunity to hear advocate from the Supreme Court. Now, basically, even in Assam or in the most of the parts, you see, we are still lagging behind in many aspects, especially when it comes to education. When we were in colleges, we were fortunate, I think, to be in some of the good colleges outside Assam. So, like there, we used to have regular lectures by eminent personalities, experienced advocates from Supreme Court, High Court, judges. All of them were used to come on a regular basis. But that trend or that thing is not, seen over here in this part of the state. So these webinars are an excellent platform, wherein we can interact with a lot of people, and even the speakers can interact now. As for you, I think all the participants, they are from every nook and corner of the state, right from Tinsukia up to Dhuburi. There are participants from almost all the districts, like that. So it has been a very wonderful experience for all of us. So with that, I would, you would like to say anything?
No, that's all. Thank you. I'm glad to be a part of the webinar today, and it's been a good experience for me also. Thank you very much, and wish you all the very best to everyone.
You have been actually, people like you are an experience. An inspiration for other students also, because our students who are studying in the law colleges, for them Supreme Court or Delhi High Court is very far. They don't think of
yes. If you think too much, it becomes very far.
That's what I know, because I think the participants know that. I don't know. Today's speaker's full name is Mr. Abir Phukan, who basically hails from Dibrugarh. So he is he is a resident of Assam. He's an Assamese. So I would like to say, request actually Mr. Phukan to kindly end this meeting with something in Assamese to all of my participants, so they'll get an inspiration, and maybe hopefully some of them in future will share the office with you in Supreme Court as well in Delhi. Thank you, sir.
So লিগেল প্ৰফেশ্যনটো সহজ নহয়, কষ্ট বহুত কৰিব লাগে আৰু বিশেষকৈ প্ৰথম কেইবছৰমান বহুতেই কষ্ট কৰিব লাগে। গতিকে মানে এইটো লটো পাছ কৰি যে তোমালোকৰ মানে কষ্ট শেষ হৈ গ'ল সেইটো নাভাবিবা, কষ্ট একচুৱেলি তাৰপিছত আৰম্ভ হয় আৰু বহুত ষ্ট্ৰাগল ফেচ কৰিবলগীয়া হয় এজন লিটিগেটিং লয়াৰৰ কাৰণে। ফাৰ্মত জইন কৰিলে বহুতখিনি হাৰ্ডশ্বিপ কমি যায়, বহুত কষ্ট কমি থাকে। এটা মানে মাহেকে এটা তোমাৰ এটা কিবা এটা চেলাৰী এটা আহে, গতিকে সেইফালৰ পৰা কিছুমান এচুৰেঞ্চেছ থাকে, গেৰেণ্টিজ থাকে কষ্ট নোহোৱাৰ। কিন্তু নিজে যদি প্ৰেক্টিচ কৰোঁ বুলি ভাবা আৰু এইবিলাক ডিচিজন পাৰিলে শেষলৈকে নাৰাখিবা, আগৰ পৰা ভাবিবা, ইণ্টাৰ্ণশ্বিপ কৰিবা ভাল মানে লয়াৰ অফিচত বা ক'ৰবাত ফাৰ্ম চাৰ্মত কৰিলা বা এটলিষ্ট কোৰ্টলৈ গৈ কোৰ্টৰ প্ৰচিডিং চাবা, বহুত কথা শিকা যায় তেনেকে। গতিকে আৰম্ভণিৰ পৰাই যদি সেইবিলাক অলপমান গুৰুত্ব দিয়া, তেতিয়া ডিচিজনটো মানে লাষ্টত লওঁতে বেছি কষ্ট নহয় তেতিয়া। গতিকে আগৰ পৰা ডিচিজনটো লৈ থ'লে ক'লে যাবা, ক'ত প্ৰেক্টিচ কৰিবা, কি এৰিয়া অফ ল প্ৰেক্টিচ কৰিবা, সেইবিলাক আগৰ পৰা অলপমান যদি তুমি জানা বা এটা অনুমান কৰিব পাৰা যে মই ক্ৰিমিনেল প্ৰেক্টিচেই কৰিম, বা তুমি এনেকুৱা এটা কথাও ভাবিব পাৰা যে মই এবছৰ বা 2 বছৰ বা 3 বছৰ চাম, মই চব ধৰণৰ প্ৰেক্টিচ মই এয়া কৰি চাম, কিন্তু 3 বছৰৰ পিছত মই ডিচিজন ল'মেই যে মই আল্টিমেটলি কি পাৰ্চিউ কৰিম। তো তেনেকুৱা এটা মাইণ্ড ফ্ৰেম থকাটো মোৰ লাগে যে বিৰাটেই কামত আহিব তোমালোকৰ পিছত। আৰু মানে এতিয়া ইণ্টাৰ্ণশ্বিপ আজিকালি খুব কৰে, চব ল কলেজ ইউনিভাৰ্চিটিৰ ষ্টুডেণ্টছবিলাক ইণ্টাৰ্ণশ্বিপছ বহুত কৰে। চ' ইণ্টাৰ্ণশ্বিপছটো কৰিব লাগে অলপমান চিৰিয়াছলি। আৰু যোনটো কথা ক'লো যে মানে তোমাৰ কোৰ্টত গৈ প্ৰচিডিংছ ৱাচ কৰাটো খুব গুৰুত্বপূৰ্ণ।
One last request.